Welcome back, Free Movement Nation. This is Unchained Frequency, your show breaking down your lawful rights behind the wheel. In last week's intro, I've given you my intro of who I am and what I am. But I'm going to lay down the big picture. Right to travel. It's about your constitutional right to move by vehicle, interstate and intrastate without arbitrary restraints. So today, in episode 2, we go deep into the roots, before cars, before highways, to see how America's founders and early courts understood free movement, because if you don't know the foundation, you will never know when it's being attacked. Here's what we will cover today. 1. The Constitution's starting text. Article 4, Privileges and Immunity Clause. 2. ClauseCorfield versus Coryell, 1823. Early judicial interpretations. 3. Crandall versus Nevada, 1867. State cannot tax your exit. 4. Edwards versus California, 1941. Lincoln movement to national citizenship. 5. Wrap up and how all this matters to you on the road. Let's begin with what the Constitution says. Article 4, Section 2, Clause 1 states, the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. United States Constitution, Article 4, Section 2, Clause 1. All of the references I'm going to give you, it is your duty to make sure you look this up, read it for yourself. Don't just take what I tell you or give you the information and run with it. Read, people. So you want to go to law.cornell.edu. Now back to the segment. This clause is sometimes called the Privileges and Immunities Clause. It means that a citizen of one state gets certain fundamental rights when they go to another state. It doesn't guarantee every right, but it guards against discriminatory treatment by states based on your state citizenship. In Coryell versus Coryell, 1823, Justice Bushrod, Washington, sitting in a circuit court, interpreted that clause in an early case, fjc.gov, Federal Judicial Center, Coryell versus Coryell, 6F Case 546, CCED PA 1823, number 3230, 3rd Circuit. Coryell involved a New Jersey law that restricted non-residents from gathering oysters and clams along New Jersey's waters. The challenger said it violated the Privileges and Immunities Clause. Justice Washington's response, the clause protects fundamental rights, but not all rights that states grant their own citizens. He listed some rights he thought were fundamental. Protection by the government, allowing to pursue one's livelihood, access to the court, etc. He rejected the claim for oyster harvesting in that case because Washington concluded that right was not amongst those fundamental ones that the clause protects to non-residents. QMB.com, United States District Courts for the Eastern District Courts of Pennsylvania, 6F, Case 546, 1825. Coryell's real importance in that diction, it gives us a window into how early jurists thought about what privileges and immunities might mean. The idea of fundamental rights of citizenship that travel might belong to. That interpretation later influenced thinking about the Privileges and Immunities Clause of the 14th Amendment during Reconstruction. ConstitutionalLawReporter.com, Coryell versus Coryell, and the Privileges and Immunities of American Citizenship. Scholarship.law.nd.edu, Rediscovering Coryell versus Coryell. Jump ahead to Crandall versus Nevada, 1868, also referred to 1868. I'm sorry, 1867, also referred to 1868. Supreme.justia.com. Since all citizens have the right to move around freely, a state cannot impose taxes that interfere with their ability to leave. In Crandall, Nevada had a law that required railroad and stagecoach companies to collect a $1 tax from every person leaving the state. The court struck that down. The logic: a citizen has a right to move freely, and a state can't impose a tax on that exit that would burden movement. One way the court described it is this: imposing a tax on departure would hamper that fundamental right. That case is often cited in later movement rights cases. Something to emphasize: this right to leave the state is not explicitly spelled out in the Constitution text, but the court read it as implicit in liberty and the structure of the Union. Edwards versus California later refers to Crandall as precedent. Law.cornell.edu, Edwards versus People of State of California. So you have a foundation. The Constitution promises privileges and immunities. Early courts interpreted that to conclude things like free movement and freedom to exit states. Edwards versus California, movement and national citizenship. Now let's move to Edwards versus California, 1941. Supreme.justia.com. Edwards versus California, 314 U.S. 160, 1941. Here's the setup. California passed a law making it a misdemeanor for anyone to knowingly bring into the state a non-resident indigenous person. The idea was to prevent poor non-residents from coming into California and becoming a burden. The Supreme Court struck that law down, holding that you cannot criminalize interstate movement of indigenous persons. The state cannot punish someone for bringing a non-resident poor person into its borders. The court saw that as an unconstitutional burden on interstate commerce and on the right of movement associated with national citizenship. In the majority, the court says that even though the right of free movement isn't spelled out explicitly in the Constitution text, long before the 14th Amendment, it was recognized as a right fundamental to the national character of our federal government. Law.cornell.edu. What the Supreme Court did was struck down that statute because it was unconstitutional, period. And it refers to Crandall versus Nevada as prior recognition of that exit right. In practical terms, Edward connects the freedom of movement to national citizenship, meaning states can individually gatekeep who may travel into their territories, especially based on financial status. Next segment is the census's relevance to vehicle travel. Let's tie together what we've covered so far. The Constitution, Article 5, gives you a guarantee of privileges and immunities when you go from state to state. Coryell versus Coryell shows early judicial thinking. The clause covers fundamental rights, though not every state granted it right. Crandall versus Nevada protects your right to exit a state without state-imposed tax burdens. Edwards versus California affirms that states cannot criminally exclude or penalize interstate movement of individuals, especially indigenous, linking that right to your citizenship. All of that is background that later cases build on when the court applies travel rights to modern issues like state residency laws, licenses, and vehicle movement. Even though these older cases don't mention cars or traffic stop, they ground the bigger idea that movement is a civic right, not a governmental favor. Important to remember, You now know how the Constitution and early Supreme Court cases, Corfield, Crandall, and Edwards, built the legal foundation for the right to travel. That right isn't granted by government. It's protected from government interference. But here's something crucial to understand before we close. When we talk about traveling versus driving, words matter. These aren't just semantics, they determine jurisdiction. Let's look at what the older law dictionary said before modern statutes changed the language. Bouvier's Law Dictionary, 1856, defines driver as 1. Employed in conducting a coach, carriage, wagon, or other vehicle with horses, mules, or other animals. A driver must possess reasonable skill and be of good habits for the journey, because should an accident or injury occur, both the driver and his employer will be responsible. That's interesting. That takes me back to what? The Sixth Amendment. The Sixth Amendment gives you what? The right to face your accuser, and there has to be an injured party, which most corrupt courts, pseudo courts, kangaroo courts, they don't honor. They like to use what is called obfuscation. That's what they're good at doing. Black's Law, 4th edition, revised, defines drivers as 1 employed in conducting or operating a coach, carriage, wagon, or other vehicle with horses, mules, or motor car, though not a street railroad car, a person actually doing the driving, whether employed by the owner to drive or driving his own vehicle. Wallace versus Woods, 340 MO 452-102 SW 2D 9197. So both definitions make it plain. A driver is someone employed in commercial transport, not a private citizen simply moving from place to place for personal reasons. That's why I don't use certain commercial terms when traveling. When I'm on the road, I'm not driving a motor vehicle. I'm traveling in my private conveyance or automobile, which are lawful, non-commercial terms describing private use of the roadways. See, the moment you identify yourself using commercial language, driver, vehicle, motor vehicle, individual, or person, you step into their jurisdiction. Those are terms of art tied to commerce and corporate fictions, giving public officers the authority to regulate you under administrative or commercial codes. But public officers only have jurisdiction over commercial activities, not over private citizens traveling for personal reasons. The so-called road pirates, as I call them, can only act when you've entered into their system through contracts like the driver's license, state ID, or vehicle registration. So remember, your words establish your standing. Your standings determines jurisdiction, and jurisdiction defines whether your travel is a right or a regulated privilege. Keep that in mind next time you hit the road, or rather, when you travel. Next week in episode 3, we move forward to Shapiro versus Thomas, 1969, the landmark case that revived the right to travel under the 14th Amendment. We'll see how the court recognized travel as a weapon against state discrimination and how you can use that knowledge to protect yourself today. Until then, stay alert, stay lawful, stay free. This is Unchained Frequency, signing off.